we're all set. Are we at our 10 o'clock, 10:01? Okay. So the first order of business is to welcome Mr. Brad Aldrich to the board. Welcome, Brad.
Thank you.
We're very pleased to have you. I also want to take this opportunity to say thank you to Bill Davies, who served for a very long time on the board and was a very valued member and always had a couple of corrections. And Brad, we might pass this task on to you in proofing the minutes and the documents. So we're looking for volunteers.
Challenge accepted.
You also have a lot of institutional memories,
Absolutely.
which I found incredibly valuable in terms of knowing the precedents, knowing the law. I will really miss that.
Yeah. Let me take this opportunity to thank all of you for the time you put in. We are hoping to talk a little bit later in the meeting about the possibility of how we can engage alternate members of the board to just bring a greater presence to the issues. So again, welcome Brad, and I think there were bagels brought in your honor, so.
Yes.
Oh. Festive, maybe.
Lots of bagels too, so everyone's got to leave with one if you don't enjoy the meeting.
All right, so we have an opportunity for public comment on non-agenda items, and I'm presuming that that is what this group would like to do. Is there a spokesperson?
Yes. Ready for me?
Yes?
My name is Lori Berger. I'm part of a group of residents called Neighbors for Healthy Communities, and I have along with me Denise Gansford-Patrick, Sean Gansford-Patrick, and Melissa Danilowitz. There are 10 other parties that are part of the process who have word commitments today, along with other community group members who support us along this way. We're residents that came together in the villages of Graniteville and the town of Barry in opposition to the Northeast Materials Group, asphalt, and crusher operation. Over the past 5 years, we have shouldered the impacts of the crushing operation, the asphalt operation, and I'd like
May I just interrupt you, please?
Yes.
To ask the purpose of your presentation today?
Well, we're here to address the apparent violation that we feel that is being placed upon us by a crushing operation that is working on the tract of land adjacent to the current crushing operation, which I can show you here if you can see it. This is the current crushing operation that is now under the current Act 250
Okay.
hearing. We have now become aware that there is a crushing operation by Northeast Materials Group on the tract of land of Rock of Ages, a mere 3,200 feet in approximation from the existing tract and 1,500 feet from the closest resident. There was a Supreme Court decision in August of 2016 that stated that crushing there was no apparent previous existing crushing on this location pre-1970, therefore required a land use permit, and that's why we are here. This is on the same tract of land in a close location or proximity, providing the same impacts that are being sought after to be reviewed in Act 250, and we're here to ask why this is going on with such complacent response. I will point out the chronology of how we have reported this. We reported it to the Act 250 district coordinator on 410. We get a response back on 412 from just showing basically an echo of what we represented from the enforcement officer. I then sent a letter out to you, Chair Snelling, why enforcement was not being taken, as this is an apparent violation of the Supreme Court order. And then following that, we received a response from Greg Google, who telephoned, and a response email, both stating that the action that should be taken by us is a JO. We're here to say that we do not feel that a JO is our responsibility. This is seemingly a black and white violation to us, and honestly, I'd like to know why we did not receive any response from you, Chair Snelling, and also, if you need to help me understand this, because I would like to know, with what you're presented with as far as Supreme Court decision, I mean, I have to wonder if there was has there been any communication with Rock of Ages or Northeast Materials Group beyond your enforcement officer, Aaron Brondike? And I would like to know if there's been any communication with Rock of Ages in regards to this matter and what is going on, because if not, I just don't understand how this can be going on. And I also would just like to hand out, you know, in good faith, we have, well, you know, 13 members are, who received party status. For 5 years now, in good faith, we have gone through the process and gone through it, I think, as honestly, as passionately as any group of members can who are trying to preserve their community. You'll see a list, and if I can hand this out, just so you guys can see what we've been through and what we've been going through. It's 5 years of quite a bit of work by us, and I'm also at the same time going to hand out a letter that was sent to Chair Snelling. This has required a lot of work and heart and soul from our people. As you can imagine, in going against industry, we're out-resourced 10 to 1. We were lucky enough to, at the beginning of this process, get Vermont Law School as a pro bono representation for us. In these current hearings, we have not had the law school, but we were fortunate enough to have members of the community, such as Mr. Stanek, to help us along the way. To expect us to shoulder again the burden of filing for a JO when that should not be the course of action taken when there's a violation is just ludicrous. And I really do, so I hope you can just answer the questions that I did present you on why we did not get response and if there has been any communication.
I did respond through my staff, General Counsel Greg Gold. So that was a response, in my opinion. I'm sorry that it didn't seem that one.
Okay.
I do think that there are some misunderstandings or misperceptions about this case. I think the recommendation of asking for a jurisdictional opinion is important because in reviewing the Supreme Court case, it was referred to a very specific location, which did not include the entire tract. And please correct me, gentlemen, if I'm wrong. And the new location of the crusher in what I believe is near the so-called Smith pit, we do not know, I do not know, whether or not we have jurisdiction, which is why the question of jurisdiction arises. I am not going to ask to have something, any enforcement action happen unless we're certain that there is in fact jurisdiction. You've been working on this for 5 years, so I think you all understand the depth of the detail that's important in such things. And I'm really not certain what else to share. I mean, we've talked about this quite a bit, and some encouragement to go and enforce, but I really don't find that an appropriate response to simply enforce because people are asking you to enforce. You need to know that in fact there is jurisdiction. So that is the question in my mind at this time.
I have a little different understanding of that, so I'm gonna let Mr. Stanek speak because we have been in communication with us in regards to the Supreme Court decision.
For those that may not know me, my name is Ed Stanek. I'm a resident of Barry City. I was employed by the state of Vermont for 32 years as a district coordinator for the District 5 Environmental Commission. In that capacity, I was deeply involved in enforcement, particularly before the era when we even hired environmental enforcement officers. So I've issued numerous notices of violation. I did numerous financial penalty calculations. I testified in numerous trials before the environmental court and before that the Superior Court. Several of the essential seminal decisions on Act 250 jurisdiction on earth extraction projects originated in District 5. And I'm talking about cases that went through not only the Environmental Board, but all the way to the state Supreme Court. A few examples: Tucker, which was the first crusher case. What is a substantial change for a crusher? The Monash Corporation up in Lamoille County, substantial change on numerous of his tracts in Lamoille County. The Bigford Quarry in Marshfield, just 3 examples. But the matter before you is one I think that's a challenge for this Natural Resources Board in terms of upholding the integrity of Act 250. This case has been to the Supreme Court of Vermont not once, but twice. Any reasonable reading of the Supreme Court decision would lead to the conclusion that it was all about the tract of land, not the portion or the site on the tract of land, but the tract of land. Now, jurisdiction over the tract, the Environmental Board itself said, is the bright line, quote unquote, for determining jurisdiction. And that was first decided in the Environmental Board's Blodgett decision. And that Blodgett decision was reconsidered years later in the so-called Stony Brook decision. And in the Stony Brook decision, the Environmental Board upheld the basic practice of Act 250 that jurisdiction has everything to do with the tract and not the amount of land involved in the project. That last trigger for jurisdiction only applies to state projects. When we used to calculate to the inch, sometimes I thought, whether there was 10 acres of land involved in disturbance for a municipal estate project. But that is not the test for jurisdiction for a commercial project. If you read the Supreme Court decision, the 2 corporate persons involved in this case, Rock of Ages and Northeast Materials Group, were given every opportunity to provide evidence, first to the Environmental Court, then to the Supreme Court, that there was a pre-existing crusher operation somewhere on that tract of land over the last 100 years. You can read that decision. The only proof they came up with was a photograph of a crusher on that tract of land somewhere around the 1920s. That's the proof. That's the only proof. They have the burden of proof under all the case law to prove that they were pre-existing use. They had no proof. It was a crusher on a separate piece of property. They tried to hang their hat on it, not their tract of land. So the point is this. Right now, it's an insult to injury, not only to these members of the public, but to this board. Because if you look at this, it's the same 1,100-acre tract of land. The Rock of Ages tract of land begins over here and runs in a diagonal over in that direction. Same jurisdictional tract of land. Same corporate persons. Northeast Materials Group, which is a corporation incorporated originally in the state of Washington, now doing business in the state of Vermont. Same corporate persons. Same industrial land use. There's no difference here. To send these folks back through the abyss, quite frankly, of a jurisdictional opinion at great expense is unreasonable. Really what's going on here is the corporate persons should be challenged by your enforcement staff as to why this is not already subject to jurisdiction because of the Supreme Court ruling. It should not be seeking a new JO. It should be res judicata, that the applicants cannot challenge the facts which have already been litigated to death in the Environmental Court and before the Supreme Court. What these folks are asking for here is accountability by the state of Vermont. They just filed, in the pending case, which we will not talk about, before the District Commission, 50 pages of proposed findings of fact, which your council have a copy of. It's all a public document. You could take a glance at that to get a glimmer of the impacts they've been putting up with for 7 years. They have not sought the NRB to enforce the fact that the crushers ran. They've been running illegally for 5 years. They've sought no enforcement after the fact for that violation. And I can name cases where the board did go and seek financial penalties once jurisdiction was established. They're not even seeking that. They're looking for environmental justice now because of this new crusher, which is plopped down right in the village. Same dust, same noise, same truck traffic. I want to point out the truck traffic. Under the crusher that's been running for 7 years, that was labeled the Act 250 site, those trucks, along with the combined asphalt plant, leave the site and travel on Brandonville Road through the heart of the village. There's a lower village and an upper village. That same site, which is subject to the District 5 review, and by the calculations by the applicant's own admission, the combined trucks, asphalt and granite, could lead to one truck every 3 minutes going through the village, hauling from the stockpile site. Well, this is the same stockpile site that we feel the illegal crusher is using. They're crushing here, they're hauling on their internal road system to the same stockpile site, and then when trucks come to haul to the regional markets, they're hauling along Brandonville Road. This makes no sense. This is a series of impacts, the same industrial land use on the same track that's under the review of your District 5 Environmental Commission. How in the world anyone can conclude that the same land use on the same track just moved, is not subject to Act 250 is really breathtaking. So anyway, I'm here to make a plea on behalf of these people that you take action. If any JO has to be requested, your EEO could ask that. Coordinator, I know, cannot issue a JO on his or her own motion. But a staff member of the NRB, if you feel the JO is required, which really is not, your staff person should ask for it. And then the NRB, under 10 VSA 6027, your powers, you can pursue the jurisdictional decision through the appellate process. But the bottom line is, this cries out for enforcement. The lack of enforcement here is not only an environmental injustice to these people, but it's an insult to the integrity of Act 250, and I ask you to take enforcement action.
Thank you very much for your presentation. I appreciate the materials that you've given us. We are not in a position to make any decision at this moment, nor to have any further discussion. We do not make those decisions as a board. And
May I ask, can we expect a response of some type from the board?
what kind of response would you like other than what you have requested?
I want a better understanding. For 5 years, we have dotted our I's, we've crossed our T's, we've respectively done the dance. We have met our burden of proof, and I personally want an understanding, where is the system broken? Why is this not being dealt with? For 5 years, we have done exactly what we are done. I wasn't rude to you, please don't be rude to me. For
I'm not being
5
rude.
years, we have done exactly what we've needed to do to meet our proof. We've done that. Here we are, 5 years later, we're sitting here again. She has a mom freshly out of the hospital from surgery. I'm burying my father this weekend. And where are we? 5 years later. We're still, all we want is what we've proven. We want this to be dealt
You
with.
have used the courts. You have followed the process.
Absolutely.
That is the process that is supposed to make that decision. All right?
There is one issue I have is, I was at both times where they presented to the Supreme Court, and I'm Sean, I'm the son. I grew up right in Graniteville pretty much my whole life. Now, the whole understanding I have is the Supreme Court decision was based on a cognizant change. That Northeast Material claimed that since the rock crusher was on the property, since within the last 100 years, that any new rock crusher going into that area does not represent a cognizant change. Their argument was that it's a quarry operation, rock crushers come and go, so there's no change. Now, they were supposed to provide proof that a rock crusher was on that tract of land previously. They weren't able to. So from my understanding, the Supreme Court said that any rock crusher on that tract of land isn't a cognizant change, requiring an Act 250 permit. Now, after that ruling came through, for Northeast Material to start a new rock crusher on the same tract of land, how is that not a blatant violation of the court order that claims that any rock crusher on that same tract of land is a cognizant change? And causes of change is the language that was used to provide the necessity for a 1950 permit. So how is a new rock crusher not a direct violation of that? And isn't the point of the environmental board to seek out such violations and investigate and dole out whatever fine, punishment, whatever you have the authority for?
It's
That's-
hard for us to
That's the thing we don't
understand.
understand, is we went through the court process, the Supreme Court flat out said, yeah, you're right, it shouldn't be there. Now they've started a new one and we're told we have to go through the exact same process, which is expensive and time consuming.
So, oh, I'm sorry.
No, go ahead, it's fine.
So, I know some of you, Greg Vogel, I'm the General Counsel for the Natural Resources Board. I want to thank you all for your dedication and passion. It really is admirable. I really do appreciate it. My colleague Pete Gill and I have spent some time looking at your concerns and at the two Supreme Court cases that's come down with respect to the jail that you're talking about. And we frankly have a very different reading of it than Mr. Stanek has and that I think you have. To us, the real purpose of this decision is actually to indicate that on a big tract of land like we're talking about here, somewhere around 1,200 acres, it's necessary to look at the specific area that's in question before doing or while doing the cognizable change analysis. So with respect to the area that the current crusher, not the current crusher, the crusher that's being permitted now, with respect to that area, the court has found that there was a cognizable change because NEMG could not produce a history of crushing at that site.
Okay,
Let me just finish. The same analysis would need to be done, in our opinion, with respect to other areas of the 1,200-acre tract in order to determine whether or not there's been crushing in other areas in a historical timeline. And that's sort of the point of these two cases that have followed Supreme Court precedent through the years. In fact, if I recall correctly, and I don't have the case right in front of me, but if I recall correctly, there was a specific finding in one of the two cases that there was crushing in 69 and 70 in the Smith Quarry. And that was without even looking at that specific site. So the court was not reviewing that specific site, but as a side, it did find that there was crushing in 69 and 70. Whether there was crushing before that or after that, I have no idea. But that would be a question for the coordinator in his or her process of drafting a jurisdictional opinion. That's why it makes the most sense, in my opinion, to go that route.
now what's to stop them, let's say we do this whole process again, it goes, well, I just want to say one thing, what's to stop them from, let's say we get this new crusher under an Act 250 permit? What's to stop them from moving or setting up another crusher
Elsewhere.
just 2,000 feet away and starting a new one, never set
That's
again?
basically what we
Yeah,
want.
so at some point,
So what's the point of an Act 250 permit process if you can just set it up all willy-nilly, wherever you want?
so if there's a history of crushing that predated 1970, which is when Act 250 came to be, and there's a history of crushing that sets up a time frame that allows a coordinator or a court on appeal to determine that there's no cognizable change for that area on a 1,200-acre tract, likely a court or a coordinator will find no cognizable change, therefore no jurisdiction with respect to this activity. So when you're dealing with a 1,200-acre tract, it's frankly very different than dealing with a 5-acre tract. On a 5-acre tract, if there was no crushing, very likely you're not going to find a place on a 5-acre tract where you could then go ahead and crush. It's going to be more than likely considered as one whole entity. But on a 1,200-acre tract, you're talking about a very different type of analysis, which is what was developed in the course of these two Supreme Court cases.
So I would like to ask the board members if they have any questions for you. Any comments or questions? No? Okay,
I'd
thank
like
you.
to follow up quickly with something Mr. Google said. You stated that you felt that you felt it was different in your interpretation of the Supreme Court case. I disagree with that, but having said that, then frankly, I don't understand why Northeast Materials now and has been able to continue to operate, which there was, you're stating that there was jurisdiction over the current location at 751 Graniteville Road. to stop crushing in August, but yet they've been allowed to continue to sell aggregate. The aggregate from this new location is being brought to that location, still bringing the impacts. Why has that not been stopped? Why was that not stopped from August?
I'm not sure I'm following, exactly what you just said. So crushing at the, they've been crushing, are you saying, at the location for which they are trying to get a permit?
No, she's saying that the crushing, although the crushing's at a new site, the impacts are the very same as the case already litigated, because they're bringing the aggregate to the stockpile site, which is the subject of the Supreme Court holding, and from that stockpile site, the truck traffic originates along the route which has already been litigated. So the impact, which the Supreme Court said were a substantial change at a minimum from the stockpile site and the hauling of trucks, is the very same.
Right.
That's the point I believe she's trying to make.
Right, they don't have a land use permit. Why were they even allowed since August, since that decision, to even sell from that location? Why are they able to operate when they don't have a permit?
So again, the question becomes whether or not there was some sort of timeline that sets up the history of crushing at the site where they're currently crushing.
Okay, but from what I understand from the Supreme Court thing, they provided absolutely zero proof that there had been any crushing at any point in time in history on that tract of land. That they made a claim that they couldn't even prove that there was rock crushing in the 70s on a tract of land off their property. That's the thing that I don't understand.
So their burden in this particular case, in the Supreme Court cases, was to address the impacts of that specific area. Their burden was not to address the impacts or the history of crushing in the remainder, however many acres it was. That was not what the focus of this particular case was. And if I recall correctly, the decision actually does note that there was some recorded history of crushing beyond the particular scope that was at issue in those cases.
If I may have a quick response, this strains the analysis of the jurisdiction to the level of absurdity, because although on one hand I would agree it is a very large tract of land, we are not talking about a new crusher site on that tract of land in the town of Williamstown. We're not talking about a new crusher on the same tract of land in the village of Websterville. We're talking about a crusher on the same tract of land in the very same village, only 3,000 feet away, in a case which a reasonable reading of the Supreme Court would indicate, as folks have pointed out, the applicant could produce no proof of any crushing anywhere on the tract of land. So here, well, I guess I'll just end by saying, you know, this case is a perfect example of a topic that's been raised over the years. And that is, if for whatever reasons the board is unable or unwilling to enforce, then there should be a citizen suit provision in the state of Vermont to allow the citizens to enforce the law if the state entity will not do it. The impacts on these people are so real. If you've been to their houses and you can see the dust in their houses, if you've experienced the traffic on Graniteville Road, there are significant criteria in 5 issues. I know we're not going to talk about the pending case. Again, I suggest and encourage you to take a peek at the 50 pages of proposed findings, and you will see that the impacts from this new crusher site compared to the crusher site subject to the permit review are the very same. There is no difference. To require another jurisdictional opinion is really interpreting the law to the point of absurdity, to the disadvantage of these residents and these taxpayers.
Thank you very much for your comments. I think at this point it would be appropriate to resume our meeting. We're not prepared to discuss this further today. I will certainly have further conversations with legal counsel and pursue the issues that we have been pursuing in response to this case.
And as I said, I hope that we get some type of response. I understand that you have to discuss this, but to sit here 5 years later and still feel like we are dealing with a system that's a self-reporting system that basically is putting secondary the health and the safety of the residents of Vermont, which is exactly the premise of Act 250, to safeguard that, is just totally ludicrous to me. It's totally, I can't even comprehend it. It's hard to be a voter in this state at this point, to tell you the honest truth. It's something, I've always took a lot of pride in because my parents were not, they legal immigrants, but they were not. At 78 years old, my mother became a voter last year because of this case.
Well, as I said, we're not prepared to have further discussion today about this. I do appreciate your comments and the materials you provided. And we will, as I said, have a conversation with legal counsel and proceed as we go.
Thank you.